Good evening. This meeting is called to order. May we have a roll call, please?
Commissioner Fiani,
Here.
Commissioner Drick,
Here.
Commissioner Helserman,
Here.
Commissioner Domas is absent, Commissioner Sample,
Here.
Commissioner Nakagiri,
Here.
Commissioner Deaton is absent, Commissioner Panovich.
Here.
Commissioner Gross.
Here.
Quorum is present.
Thank you. Is there a motion to approve this evening's agenda with the addition of item 6.6, resolution authorizing the purchase of a new ambulance on an insurance claim?
Would move the approval of the agenda with the addition.
Second. Sample.
Moved by Commissioner Helserman, seconded by Commissioner Sample. Any discussion? All those in favor, please say aye.
Aye.
All those opposed? The motion is approved. At this time, we have the call of the public. If anybody wishes to address the board, please submit a card. We ask if you would note your name and municipality, and you'll have 3 minutes.
Hannah Suds, Hamburg Township, followed by Steve Williams, Marion Township.
Thank you.
Hello, Commissioners. I brought a book to share with you today. This is by psychiatrist Richard A. Gardner, and it's about pedophilia. I've marked some passages for you, and I'll share 2 of the milder ones now as a preview. Sex abuse is not necessarily traumatic. It is because our society overreacts to it that children suffer. I think that means that when it comes to child sex abuse, the main problem is not the people who commit it, but the people who object to it. And I had a hard time believing that a child psychiatrist would say such a thing, so I bought his book. And he did in fact say this. These quotes are not taken out of context, and they are not nearly the worst of what's in here. Now, Dr. Gardner died in 2003, but his legacy lives on. There is still a treatment program based on his teachings. I know this because my ex hired the owner of that treatment program to be an expert witness against me. This expert referred to Dr. Gardner's teachings as a basis for her opinions, and the transcripts are all here. This expert said, "The only explanation for a child rejecting a parent has to be a programming. There is just no question." So according to her, abuse does not make a child reject their parent. No, she said, the worse the abuse, the more they want to bond with their parent. So let's think for a moment. Say you discover your spouse is abusing your child. Don't overreact, they're bonding. If that child rejects the other parent, that would be your fault. You must be programming them. Dr. Gardner says it is not okay to alienate a child from the parent who has abused them. It is okay to sever contact with the parent angry about the abuse, but not with the parent who has committed the abuse. Does that all make sense to everyone? It made sense to Judge Susan Ann Longsworth, who listened to this expert and quickly ordered my kids to be deprogrammed. The expert admitted she'd never spoken to my kids, but Longsworth didn't mind. She didn't seem to pay attention to the experts who had spoken with them anyhow. She preferred the one who had not. She listened to the one who was paid $11,000 to testify against me, who would profit tens of thousands more if she could convince Longsworth to order my kids to be deprogrammed by her. Apparently, Longsworth was unbothered by the glaring conflict of interest or the links to Dr. Gardner with his thoughts on pedophilia. None of that was a concern. So she ordered my kids to be deprogrammed, starting by severing all contact between them and those who believed them. This included cutting contact with their individual therapists. I would need to be deprogrammed too. I would need to provide a written statement, a letter of apology saying my accusations of abuse were all a big lie. I would have to say their dad is safe for the kids, he always was, and I regret ever saying differently. Remember this letter because I'm going to come back to it in the second call to the public when I finish this story. Thank you.
Thank you.
Steve Williams, Marion Township.
Hello again. This article I gave you today, I would highly recommend it. I know you have more than enough to read, but there's a lot of detail. It would be of great interest, I think. It gives a great explanation, but the bottom line is 4th Michigan judge sidelined since 2024. So those people who are saying, well, you shouldn't criticize the judge, you shouldn't take a judge, you should do this, you should do that. Why are you coming to the Board of Commissioners meeting? 4th judge in Michigan sidelined just like this. There are different tactics. There's a lot of details in there and everything, but the fact is, it specifically identifies the Board of Commissioners. This event, call to the public, as a way for people to be able to address these issues because it doesn't exist otherwise. There is no call to the public in the court. There is no way to talk back. You get shut down if you have an antagonistic judge. So what you guys have had to sit through is not only not unique, you're not on the leading edge, but you're close to it as a way to hold elected officials accountable. I do want to mention before I forget, I know that not all of you are online, or even if any of you are online, I don't know that I'm Facebook friends with any of you, but your chairman has a big online fan club right now. And if you ever get a chance to go and look at some of those Howell and Brighton and the mom forums and things like that, oh yeah, yep, there's a lot of it going on. I do not know why Hannah and I are the only people that have come to speak to you in person. I do not think that that reflects well on our county government that other people are afraid to come in here. But it is a fact. And somehow they think if they say this stuff online, it won't be seen by the judiciary. I don't think that's true either. In terms of psychology, one of the things that was just triggered in me is the memory of how Judge Longsworth, when for the PPO petition that my wife had put forward, she included a picture of the dog who was stolen, the pregnant golden retriever, my wife's business. Later, there were 10 or 12 puppies illegally registered. All that money was stolen from her, and the judge, what she took away was, oh, well, you say that that shadow is your ex taking a picture, and I don't think so, so you should have to go pay for a psychological examination. And she wouldn't allow her to continue. Remember, in Macomb County, both parties were ordered. My wife did the work. It was a fraction of the $2,000 that the person that Judge Longsworth was requiring, and my wife was not allowed to just complete that and get a report from Macomb County. So this is bullying, and this is interpretation, and this is somebody else looking to get the verdict that they want. She is basically out there trying to make people to come up with the answer that she wants. And how does that work now? The ex continuously tells my wife on Our Family Wizard, you should go to jail. Judge Longsworth said you should go to jail. It's the bullying continues, and it happens against my stepson as well. Thank you for your time.
Thank you.
No further cards.
Is there anyone on Zoom who wishes to participate in the call to the public?
I do not see any, Commissioner.
Thank you. The first call to the public is now closed. Next item we have is the FOIA appeals. We are going to bring back the FOIA appeal brought forward by Mrs. Fletcher. So at this time, I invite Mrs. Fletcher and Mrs. Fletcher and Mr. Fletcher up. And I also invite Sheriff Murphy and Under Sheriff Murphy, if he wishes, up as well. Thank you, everyone, for joining us this evening. Just to recap, last full board meeting we had, Mrs. Fletcher brought forward a FOIA appeal to the board. At that time, there was a thorough discussion. Mrs. Fletcher had 10 minutes to present her side. Under Sheriff Plus had 10 minutes to present the county's perspective on the matter. And then Mrs. Fletcher had 5 minutes for closing remarks. I believe we had a thorough question and answer session. I do have good news to share. I'm not sure who's all seen it so far, but there was an email exchange late afternoon today. In summary, the email exchange contains the submission of a subpoena by Attorney Combs to our Sheriff's Department, and Sheriff Murphy has acknowledged receipt of that, and Sheriff Murphy's also acknowledged beginning the process for fulfilling that subpoena request. In summary, so initially, I want to say this is an understatement. Nevertheless, thank you, Sheriff Murphy. Thank you, Under Sheriff Plus. thank you, Prosecutor Henry, for not only your leadership, but your partnership in this matter. I don't think that is, well, I think that's an understatement, but nevertheless, we greatly appreciate your diligence, your leadership, and your partnership on this, and we're very appreciative. Mrs. Fletcher,
It was supposed to go to Oakland County because I believe he was in jail in Oakland County at those dates that we know for sure that she spoke to him.
so last time when we had the appeal before us, the request was to have the phone records from the Livingston County Jail. I do appreciate the circumstances you just outlined. We actually don't have any control. The board, the sheriff, we don't have any control over Oakland County. As I recall in my notes, and as Prosecutor Henry had outlined as well, it was a request for the correspondence coming from the Livingston County Jail. So it's my understanding that the subpoena submitted to Sheriff Murphy is in fact what was desired to seek the information you're searching for or interested in.
Okay.
So with that being said, are there any other questions or anything I can provide clarity on for you or Mr. Fletcher?
So basically, yes, we were going for Livingston County, and we also mentioned that we cannot get them through Oakland County, that we have tried that process already. And my attorney keeps, I guess, telling me that that's the process she's gonna take. When we went through court 3 months ago, it got adjourned so she could get these records.
Mhm.
She did not apply till when?
Well, I got the email today at 3:50 something, and I was working the fire and ice ribbon cutting. So I didn't get it until I was on my way here because that ended at 6 o'clock. So
Not a problem. No.
there's no date on the thing that she filled out, and it does say Oakland County on it because she sent me a copy of the
The application,
the appeal or the
the application for it.
Well, first off, when you say date, do you mean the submission date or do you mean the date?
Submission date.
Okay,
There's-
well, I think Sheriff Murphy may be able to answer those questions, but
Well, I was gonna look up at the subpoena, but here's the bottom line. We've got a subpoena. I'll look at the date here in a minute, but there's date specific for, I think, October 31st
And
to
December
December 31st. If the guy was in jail and if there's records, we'll provide them. There's nothing I can do to help you get Oakland. They're not in
Yeah.
our system. You gotta do the Oakland thing for that.
Well, that's what we were kind of talking about, seeing if anyone from here could get Oakland to nudge forward for it.
we can't, the only person would be your attorney. Even if we, were to attempt to, they wouldn't even
They would.
they wouldn't even acknowledge us. So, it's just unfortunately, it's just a matter of fact in that regard. But
I have a question for you, Sheriff. If I had the dates and the phone number that they would have called if, like the weekends that, when Alicia wasn't with my brother. If I have the phone number, could we look, instead of going through all those records, could we look for a phone number that called them of the jail?
So my position is I will honor a subpoena. Okay, the subpoena says produce copies of the following items: recording of all video visitation record between Livingston County inmate, blah, 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 between October 31st, 25 and December 25th of 25.
Okay,
If there's if there's phone records or whatever, we have the ability, I'm not sure they're still there, but I mean, we have that ability to do that. But I'm only gonna do that if I have a subpoena. It's not gonna be through a FOIA.
Yeah.
That makes sense?
okay.
Yeah.
So can you do though, like instead of wasting all your time, can I give you or give a subpoena a phone number. And then when he called that phone number, that's the only number that like we would need.
The more specific the request, the easier
The-
our job is.
right, for
obviously,
sure.
But yeah, we can narrow it down. For sure. That's very
Okay.
helpful, actually.
Okay.
Any other questions or any way we can provide additional clarification?
One more question is, do we need to file, to give you that phone number, do we need to file another subpoena?
Yes, but your attorney can do that. It's
Okay.
pretty simple.
Okay,
Because otherwise it just opens Pandora's box. Everybody's gonna want everybody's inmate calls, and I'm not doing that.
right. I don't want that either.
So I'm very excited. It sounds like we've reached an amicable resolution here. Again, thank you for your leadership and your partnership, Sheriff Murphy, Under Sheriff Puss, and Clerk Hundley as well as our FOIA coordinator and Prosecutor Henry. There's been a lot of, I'll say, assistance in the background to facilitate this, more than what we usually be
Very
performed under a
grateful.
FOIA appeal. With that being said, seems to be no reason for the board to approve the appeal because
Already.
via the subpoena, you'll be receiving the information. As a formality, we only can approve it or we can only deny it. Therefore, at this time, is there a motion among the board to deny the FOIA appeal?
So moved.
Is there a second? Moved by Commissioner Panovich, supported by Commissioner Hauserman. Any, Commissioner Nakagiri?
Question, it's another choice, and this is maybe a difference without a distinction, but could the appellants withdraw their, request? Is that a possibility?
Mr. Norford, yes. So Mr. Norford, our legal counsel, has indicated that the FOIA appeal could be withdrawn by the appellants. Is there any formality for that, or is it simply them acknowledging on the record that they wish to withdraw? Mrs. Fletcher, you submitted
Yeah, I wish to withdraw
the FOIA appeal.
it. Yes.
Thank you. The board acknowledges that Mrs. Fletcher has withdrawn the FOIA appeal. Therefore, this item is closed. Thank you for attending this evening. Thank you, gentlemen. And we will move on to the next item.
Thank you, everybody.
I have one question for you. How quick does it take? We have court on Thursday. It would be,
We will do our best.
okay,
Can't promise anything, but we'll do our best.
okay, thank you.
Next item on the agenda this evening is a FOIA appeal. It was submitted by Mrs. Erica Whiting. Is Miss Whiting present in the room?
She's on Zoom.
Oh, she is on Zoom. Okay. May you unmute her, please?
I just did.
Thank you.
Hello, good evening.
Good evening, Miss Whiting. You submitted a FOIA appeal for the
Yes.
Board of Commissioners. As part of the process, what I will do is you will have 10 minutes to present your position, any background you wish to share. The board has received the background information regarding your FOIA appeal. So at this time, I'll go ahead and start the clock and you'll have 10 minutes to present anything you wish pertaining to your FOIA appeal.
Okay, good evening. Thank you for the opportunity to be heard. I am appealing the denial of my Michigan Freedom of Act information request. I respectfully ask that the denial be reversed, or at minimum, that Livingston County conduct a more specific review and release all non-exempt portions of the requested records. The denial cites several exemptions under MCL 15.243, but does not explain how each exemption applies to the particular record I requested. Michigan's FOIA FOIA places the burden on the public body to justify withholding records. General or blanket references to statutory exemptions are not enough. There should be a factual explanation explaining why each exemption applies. If portions of the requested records are legitimately exempt, I request that only those portions be withheld or redacted while the remainder is disclosed. Michigan FOIA favors disclosure whenever reasonably possible, and redaction should be used instead of withholding the entire record when feasible. I am also requesting that the county explain with specifically how disclosure of these records would result in the harm contemplated by the exemptions it has cited. If the certain is confidential information security in an ongoing investigation, I would ask why those certains cannot be addressed through appropriate redactions rather than in complete denial. My request is made to obtain information that may be relevant to Mr. Ruff's defense. I understand that the existence of pending criminal case may raise legitimate concerns, but I respectfully submit that the pending case alone should not automatically prevent disclosure of the law and does not specifically require withholding these records. For these reasons, I ask that my appeal be granted and that these requested records or all reasonably segregatable non-exemption portions of them be released. Thank you for your time and consideration.
Thank you.
Thank you.
So I'll let legal counsel speak to the legalese that she mentioned, but my position is pretty simple. So we are the custody and care folks for inmates at the Livingston County Jail. True, they are inmates, but true, they deserve dignity and privacy. And those phone calls, when they make those phone calls, it's very apparent that if they're speaking to counsel, that's covered under privileged communication. However, if we start allowing phone calls of the 300 inmates that are in there to be basically FOIA'd by anybody because they want to know if they've got a boyfriend or girlfriend, or if they're mad about something, or whatever the circumstances are, that's an invasion of privacy. I mean, that's clearly an invasion of privacy, and I'm not going down that road. We solved the last.
I understand. I just heard your
Hang
last
on,
one.
hang on.
Excuse me, Mrs. Whiten? Mrs. Whiten?
Yes, I understand.
I'll let legal counsel speak to the legalese. My position is if we have a subpoena or an order from the court to release those records, we'll do that.
Understood.
Mrs. Whiten,
Yes, sir.
you had 10 minutes to present, and Sheriff Murphy and Under Sheriff Plus and our legal counsel have 10 minutes as well. So until they exhaust their 10 minutes, if you could please refrain from interjecting.
Oh, okay, for sure. I've never done anything like this.
Understood. Thank you.
I'm good. If counsel wants to speak, God bless him.
Do I invite Mr. Norford?
Okay, so even though there is case law regarding limited personal privacy for inmate telephone calls, that does not mean that it is carte blanche. And so the privacy exemption is designed to be utilized by a public body. It's discretionary as far as whether or not we claim it. We have claimed it, and we've claimed a number of exemptions, and that is the scope of our responsibility in responding to the FOIA request. We do not have to provide an itemized list. I did notice in the appeal, there's a citation to a federal standard that is not applicable to Michigan FOIA. However, I think the sheriff's position is well supported by the law that there's a privacy interest in every single conversation that an inmate has. That does not mean that it is not without certain access protocols for the sheriff's office. Those include whether or not there might be criminal behavior happening on the call. The calls are logged and monitored. Inmates are provided that information. That is separate and distinct from whether or not these records are disclosed to the public. I did hear that there's a pending criminal case involved, as before with our other FOIA discussion on a similar topic. The mechanism to get these records would be through a court subpoena. Courts will often review those records in camera because they don't know what's in there. frankly, we have not gone through and looked at every single record that's in there. We have general exemptions that we are entitled to claim based on the nature of the request. And that response has been provided. It's legally valid. And I would recommend that we uphold the denial of the FOIA appeal.
Thank you, Mr. Norford. Mr. Norford, Sheriff, you do have a couple minutes left. Do you wish to exercise that time? No. With that being said, Mrs. Whiting, you now have 5 minutes for any closing thoughts or remarks.
These proceedings are very interesting. Thank you again for hearing me out. Is this appropriate to ask the question at this time?
So, you are permitted to, if Sheriff Murphy or our legal counsel or Under Sheriff Plus, they're not required to answer it, but you may ask it.
Okay, well, I did hear the last proceeding, and I was wondering if I could just withdraw my request or my appeal, and then try to go through another avenue legally.
Sheriff Murphy?
That would be wise.
Okay.
So, and just to summarize, the avenue, from my understanding, would be to submit a subpoena
Yes.
to the sheriff's office.
Mhm.
Is everybody in agreement with that?
Yep.
Okay. Sheriff Murphy has acknowledged, our legal counsel has acknowledged. Are there any questions, or you do have minutes time remaining? Any questions or comments do you wish to exercise the remaining time?
No, thank you for your time.
And may I consider this a formal withdrawal of your FOIA appeal this evening?
Yes, please, and thank you.
Thank you. Thank you, Mr. Norford. Thank you, Sheriff Murphy. Thank you, Under Sheriff Plus. The FOIA appeal has been formally withdrawn. This item is closed. Next on the agenda, we have resolutions for consideration. Is there a motion to approve the resolution authorizing the purchase and installation of a jail generator transfer switch equipment?
So move, Helserman.
Is there a second?
Second, Sample.
Moved by Commissioner Helserman, second by Commissioner Sample. Any discussion? All those in favor, please say aye.
Aye.
Aye. All those opposed? The motion is approved. Is there a motion to adopt the resolution authorizing a budget amendment to fiscal year 2026 for Fund 234 Federal Grant Fund?
I move the resolution.
Support, Helserman.
Moved by Commissioner Sample, supported by Commissioner Helserman. Any discussion? May we have a roll call, please?
Commissioner Sample,
Yes.
Commissioner Nakagiri.
Yes.
Commissioner Drick.
Yes.
Commissioner Deaton is absent. Commissioner Panovich.
Yes.
Commissioner Fiani.
Yes.
Commissioner Gross.
Yes.
Commissioner Helserman.
Yes.
Commissioner Domas is absent. Motion carries.
Thank you. Is there a motion to adopt the resolution approving the 2025 Deficit Elimination Plan?
So move, Nakagiri.
Support, Gross.
Moved by Commissioner Nakagiri, supported by Commissioner Gross. Any discussion? All those in favor, please say aye. All those opposed? Motion is approved. Is there a motion to adopt the resolution authorizing the Sheriff's Office and the County of Livingston to apply for the United States Department of Justice for the fiscal year 2026 bridging immigration-related deficits experienced nationwide Biden grant?
So move, Helserman.
Support, Nakagiri.
Any discussion? All those in favor, please say aye.
Aye.
All those opposed? Motion is approved. Is there a motion to adopt the resolution authorizing a contract renewal with Blue Cross Blue Shield for discounted medical billing 2026?
So move, Sample.
Support, Nakagiri.
Moved by Commissioner Sample, supported by Commissioner Nakagiri. Any discussion? All those in favor, please say aye.
Aye.
All those opposed? The motion is approved. Is there a motion to adopt the resolution authorizing the purchase of a new ambulance on an insurance claim.
So move Helserman.
Support Nakagiri.
Moved by Commissioner Helserman, supported by Commissioner Nakagiri. Any discussion?
Roll call.
Yeah, well, yep. Thank you. Any other discussion? May we have a roll call, please?
Commissioner Helserman,
Yes.
Commissioner Domas is absent, Commissioner Sample,
Yes.
Commissioner Nakagiri.
Yes.
Commissioner Drick.
Yes.
Commissioner Deaton is absent, Commissioner Panovich.
Yes.
Commissioner Fiani.
Yes.
Commissioner Gross.
Yes.
Motion carries.
Thank you. Is there a motion to approve the claims dated July 13th, 2026, and the payables dated June 8th through June 21st, 2026?
So move Gross.
Is there a second?
Second, Sample.
Moved by Commissioner Gross, second by Commissioner Sample. Any discussion? All those in favor, please say aye. All those opposed? Motion is approved. This time we have the second call of the public. If anybody wishes to address the board, this would be the time. If you could please just state your municipality and your name, and you'll have 2 minutes.
Hannah Suds, Hamburg Township, followed by Steve Williams.
Thank you.
Hello again, Commissioners. So Longsworth ordered me to jail and my kids to be deprogrammed, and I have 3 questions. During my sentencing, Longsworth said, "The court is permitted to impose a period of incarceration to compel compliance with the court order." The order she's referring to had not yet been written, but she's putting me in jail to compel compliance with it. So my first question, can a judge preemptively jail you to prevent you from violating an order that doesn't yet exist? Moving on. My sentence did not have an end date. I would be released only after my ex got my kids to New York for deprogramming. There was no time limit given to him. Which brings me to question 2. Does the power of coercive contempt allow a judge to tie your release to an action you have no power to perform? The last point, remember the letter I mentioned earlier? Let's explore that. Longsworth was overseeing a trial in which I was a witness. She ordered my children taken from me, ordered them into a program which she knew required I provide a statement in exchange for seeing my kids again. This statement must say things I believe to be false. A false statement of material fact to the opposing party while I was a witness in the middle of a trial by court order. So my last question, isn't that witness intimidation? And does absolute immunity prevent a judge from being held accountable for criminal activity? And that is a real question. So to recap, I'm in jail to preempt a violation of an order which did not yet exist. My release date is in the hands of the man stalking me. My kids are to be deprogrammed according to the teachings of Dr. Gardner. And if I want to see my kids again, I, a witness in an ongoing trial, must provide a false statement of material fact to the opposing party. No false statement, no kids. All courtesy of Susan Longsworth. All the documents are here. Dr. Gardner's book I'll leave for you, and I'll be back at the next full board meeting to talk about stalking. Thank you.
Thank you.
Steve Williams, Marion Township, followed by Mark Fosdick.
So at what point Judge Longsworth criticized my wife because after we were married, she sold her own farm in St. Clair County and moved here to Oz, as I referred to Livingston County, and it was 96 or 94 miles away. Now, state law is very clear that you can't move away from the marital home more than 100 miles without a judge's consent. And she was well within her rights, and yet she got criticized by Judge Longsworth. Now, this is in opposition to a guy who I've mentioned has moved 6 times in 6 years. And yet my wife has moved once, got married, moved. He's been cohabitating. We're now told that he's breaking up with his living girlfriend who has had responsibility for transporting my stepson to and from school. Even with that, the boy missed 19 days of school, twice the amount that's the limit set by the county, right, by the friend of the court that you guys fund. And now he's telling my stepson that he's going to move to Ohio, which he knows he can't do without a court order, without consent by a judge. He thinks he's going to get it. So now he's terrifying the boy, thinking that he's going to be moved away from his mother. And my stepson knows where Toledo is. He's been there before. He knows it's not within commuting distance of his school and all of his friends. If you do get a chance to read this, again, on page, I don't even know what the page is, but you know, it says that it refers to Livingston County. It also compares it to Berry County, where there's another incident going on. This would be the 5th incident. And it talks about how long things took to go through the process because of the institutional actors involved. In other words, there's a buddy system going on. And so these people have been dealing with this for years. But it specifically says other Michigan county boards watching this case play out in Livingston County have the same choice in front of them. So remember, you are on the leading edge, and thank you again for your time.
Thank you.
Mark Fosdick, Cohocton Township.
Thank you.
Mark Boston, the Township Supervisor. In a few moments, you guys are going to be going into your closed session to discuss a notice from Headland Solar about intervening in.
Excuse me, sir, I'm sorry, but can you please turn your mic on or speak into the microphone?
Is that on now? Sorry about
Feel
that.
free just to.
Yeah, Mark Fosdick, Cohocton Township Supervisor. In a few moments, you're going to be going into a closed session to discuss a notice that you received from Headland Solar and the Public Service Commission about intervening in their application. I've given you guys a memorandum there I put together of all the deficiencies of their notification to you. Chief among those is no official notification has ever been given to the county clerk. And under the Michigan Court of Appeals decision on May 7th of this year, a county is considered an affected local unit. And so I would urge you guys to get involved in this case. It's in line with your master plan and trying to keep our county rural. And I think it's in line with doing that. And I would recommend that you intervene. They've given you a tight deadline of July 21st. And if you do decide to intervene, one of the things I would recommend is that a motion should also be brought to dismiss their application because it has a fatal defect in failing to notify the county clerk of the public meeting or even sending a site plan to the county. Thank you.
Thank you.
I have no further cards.
Thank you.
Mhm.
Is there anyone on Zoom who wishes to participate in this second call of the public?
I do not see any, Commissioner.
Okay, with that being the case, the second call of the public is closed. We will now proceed into a closed session. Is there a motion to move into a closed session to discuss a written attorney-client privilege legal opinion pursuant to MCL 15.268 1H?
So moved, Nakagiri.
Moved by Commissioner Nakagiri, seconded by Commissioner Helserman. May we have a roll call, please?
Commissioner Nakagiri,
Yes.
Commissioner Dreck,
Yes.
Commissioner Deaton is absent, Commissioner Panovich.
Yes.
Commissioner Fiani.
Yes.
Commissioner Gross,
Yes.
Commissioner Helserman,
Yes.
Commissioner Domas is absent, Commissioner Sample,
Yes.
motion carries.
Thank you. I'd like to thank everybody for attending this evening, and we'll now move into a closed session. Is there a motion to authorize Livingston County through the county administrator and legal counsel to seek intervention in the pending MPSC contested case involving Headland Solar LLC's proposed solar project, including any necessary filings, testimony, discovery, argument, or related submissions? The county administrator, in consultation with legal counsel, is authorized to accept and use any intervenor funds tendered by Headwind Solar for the county's participation costs, subject to the applicable law and any MPSC or court-imposed conditions or refund obligations. The county administrator and legal counsel are further authorized to coordinate with Cohocton Township, Conway Township, Headwind Solar, and appropriate county officials regarding the county's participation, project impacts, and any host community agreement or related protections.
So move sample.
Moved by Commissioner Sample, supported by Commissioner Helserman. Any discussion? May we have a roll call vote, please? Please take your time.
Commissioner Sample.
Yes.
Turn my microphone on. Commissioner Nakagiri.
Yes.
Commissioner Drick.
Yes.
Commissioner Deaton is absent. Commissioner Panovich.
No.
Commissioner Fiani.
Yes.
Commissioner Gross.
Yes.
Commissioner Helserman.
Yes.
Commissioner Domas is absent. Motion carries.
Thank you. Is there a motion to adjourn?
So move, Helserman.
Is there a second? Motion to adjourn by Commissioner Helserman, supported by Commissioner Nakagiri. All those in favor, please say aye.
Aye.
All those opposed? We are adjourned.